Like I said, my name is Desmond Mitchell. I'm a policy analyst with the Bureau of Health Professions with the Department of Community Health. And to get started today, I'd like to go ahead and read a brief introduction. This public hearing is being held to receive comments from interested persons on the proposed rules for implementing a registration program for the medical use of marijuana. These rules are being promulgated under the authority of Initiative Law 1 of 2008, which was passed by the voters as Proposal 2008-01 at the November 4th general election. The proposed rules will take effect on April 4th, 2009. The purpose of this public hearing is to receive comments on the proposed rules of the medical marijuana registration program only. The intent of this public hearing is not to debate the merits of Initiative Law 1 or any suggested changes to Initiative Law 1. This hearing is being called to order at 9:05 on January 5th, 2009 at the State Secondary Complex, General Office Building, 7150 Harris Drive, Conference Room 8, Lansing, Michigan. The hearing is being conducted under the authority of the Administrative Procedures Act, Public Act 306 of 1969. The notice of public hearing was published in the Grand Rapids Press, the Lansing State Journal, and the Marquette Mining Journal on Monday, December 15, 2008. The proposed rules were also published in issue number 23 of the Michigan Register, January 1st, 2009. The notice also was posted on the website of the Bureau of Health Professions. I'm going to pause for a moment here and introduce some of the other members of the department that are present today. Sitting next to me is Amy Schell. Mrs. Schell is the policy manager at the Bureau of Health Professions. Also in the back of the room, if you could raise your hand, Ray. This is Ray Ramsdale. Mrs. Ramsdale is the Health Licensing Director for the Bureau of Health Professions. And Lori, if you could raise your hand, please. This is Lori Van Beelen. Lori is the Board Secretary at the Bureau of Health Professions. We're here to receive comments and recommendations to clarify the intent of the proposed rules if necessary. The testimony and documents presented at this time will be used by the department to determine if any changes are necessary to the proposed rules prior to adoption. Please remember that we're not here to debate the merits of Initiative Law 1, and we ask that your comments relate directly to the proposed rules and implementation of the registration program. If you have questions regarding the proposed rules, we request that you submit your questions as part of your testimony for the department's review. In receiving your comments, we request that any suggestions for change be accompanied by specific reasons why such a change would be in the public interest. When you testify, please identify yourself by name and any organization that you represent. To facilitate the preparation of the hearing record, we request that you submit your testimony in writing to the department. If you haven't brought a prepared statement with you today, the record will be left open at the conclusion of this public hearing until 5 p.m. on Friday, January 9th, 2009, to allow you to submit your comments in writing. The address where your written comments can be mailed is listed in the copies of the public hearing notice that have been made available. If you have a written statement with you today, please provide it to Mrs. Van Beelen in the back of the room before you leave today. The order of testimony is based on the sign-in cards used. I'll call you forward in the order that the sign-in cards were received. I'd also ask that all visitors please sign in so that we have a record of your presence at the hearing. If you haven't signed in, I'd appreciate it if you'd sign in now. Also, speakers will be limited to 10 minutes, so please try to stay aware of the time when you're providing your testimony. Final thing also is that when you provide your testimony, it's not required, but it would help the department a great deal if you could identify the rule by number if at all possible. So I'd like to ask our first speaker, R.D. Winthrop, to come forward.
Before I start, could I just briefly note that for a meeting that anticipates testimony from handicapped people, people in wheelchairs, and people who have difficulty standing for any length of time, this is not very accommodating. My name is R.D. Winthrop. I live here in Lansing. I've lived here a long time, almost 40 years. I'm the former Michigan OCNORML coordinator through the 70s and 80s. I was present at the creation, so to speak, of the Alliance for Cannabis Therapeutics in the late 1970s. That's the first patient right group for medical marijuana. I collaborated with the Michigan Green Cross and with the Reverend Richard Claver. I was the principal architect of Michigan's previous medical marijuana law in 1979. I served on the Public Health Department Advisory Board. I wrote the IND under which it operated. I reviewed the results of the program and reported them outside. I probably know more about medical marijuana in Michigan than anybody. Now, over the last 30 some odd years, life has changed for me. I've become handicapped. I now have a different business. I'm the owner of a film production company. I've spent the last 3 months in California arranging locations to shoot a documentary on the California medical cannabis system, which I hope will...
Slow down just a little bit and speak up for me, please.
I can't reach the microphone. I can't bend over. The last 3 months I've been in California on behalf of the Michigan Medical Marijuana Association, who I speak for today. I am chairman of the board. I'm also a card-carrying marijuana medical user from the state of California. Back on December 8th, I sent a query to you asking you to comment on the notice on your website that says this enrolls me immediately, which I don't think is the case, but in any case, I have been inside the system for 3 months. I've been in the grow rooms, I've been in the dispensaries, I've been talking with policymakers, I've been talking with activists. And I have a short message for you today, and other people from the MMA will focus directly on particular points of the rules, but the message I bring to you is a little bit broader. It was 30 some odd years ago that my great good friend and teacher, Robert Randall, who became America's first legal cannabis smoker, by proving in a federal court that what stood between him and blindness was cannabis. Not long thereafter, he and his partner, Alice O'Leary, enticed me to join their nascent movement by the force of their arguments and their moral choices and the simple argument that Bob didn't want to be the only man in the lifeboat, which he was at the time. He spent the rest of his life, some 25 odd years, doing almost nothing else but establishing a political movement that you see manifested here today. Over the course of his work, he brought medical cannabis IND-based legislation to more than 30 states. In 1979, Michigan became, I think, the 5th state to do so. We passed by, I think the cumulative margin was 133 to 1 in the legislature. We actually ran an IND-based program. We actually, despite the best efforts of federal government to sabotage us and some really heinous bureaucratic indifference on the part of certain people in the Michigan Department of Public Health, which was eventually corrected, we managed to actually obtain and distribute marijuana to cancer patients. It worked rather well. Law sunsetted, went away of bureaucratic indifference in 1985 or thereabouts. The story of medical marijuana, not only in Michigan, but in America at large, wrote my friend Mr. Randall in his book, Marijuana RX, in 1998, shortly before his death, is about the brutality of the system and the banality of the bureaucrats who are charged with managing it. It reveals the failure of elites and the success of common citizens intent on righting a wrong. It is the story of a remarkable public consensus which was ignored, denigrated, trampled, in order to maintain a deeply entrenched policy, which I should add is based on racist policies of another time and place. It is about the failure of government to trust its citizens and the consequences of that failure. He also taught me, though, that courage is nothing more or less than the ability to speak the truth when the truth is unwelcome. It's a moral virtue. It's built of the same spirit that drove our civil rights revolution in the 60s and 70s. It's a moral call. 30 years ago, there wasn't but one voice making it. I heard it. Today, there's a lot more people who have obviously heard it. Here in Michigan, 3,006,819 other Michiganders joined me in voting for this law. Kitchi Megwich, Michiganders, thank you very much. We will not fail you. MMA has a simple mission. We want to see that this state delivers safe, effective, and cost-efficient cannabis to its medical marijuana users. And to that end, we have formed. We have not been sitting on the couch watching Nickelodeon for 30 years. We've been talking with people, we've been planning, we've been improving the breed. We've been, there's a revolution in cannabis cultivation that has produced medical quality marijuana. What we got from the federal government years ago was at best 2% THC. What I get from my pharmacies in California is anywhere from 15 to 30% THC. And that's all a product of cultivation. And the rules that are made here in Michigan must do two things. They must recognize that in order to serve the people under the intention of this law, you are going to have to foster local production of medical quality cannabis. The rules are going to have to reflect the reality that it's not going to fall out of the sky, or as one spokesperson during the campaign said, they just get it, don't they? They're not getting medicine, they're getting marijuana from a street corner or whatever. Medical patients need very high quality cannabis. They need 15, 18, 20, 25% THC. It decreases the dose, it increases the titration ability of the dose, and it increases the effectiveness. Regular, they get it, don't they, marijuana in Michigan does not work for me. I require medical cannabis. We're going to be here to serve you. The MMMA is here to serve you, the state as well, and law enforcement agencies and agencies of local government who are going to have to come to us for advice. We are, after all, the experts. We are the people who know what is needed, how to produce it, how to bring it to market, and we will help you make that happen. This can be the biggest economic development story of Michigan's next decade. This is quite literally a $100 million tax revenue income stream for the state of California. Simply from the dispensaries on sales tax, $170 million in 2007 fiscal year estimate. 170-something million dollars just on dispensary sales from 500 outlets. That isn't excise taxes, those are not transfers from co-ops to dispensaries. $170 million, and we're going to drive it all off the grid and all off into the national forests and all off under the farmers' cornfields and all out of sight and off the regulatory grid if the rules do not invite compliance. You have to make it possible for us to follow your lead on the quality of the rules you make, because if you make rules that people can't follow, they won't. They will simply ignore you. And I can only say that the medical marijuana industry exists. It's coming to Michigan. There's nothing to be done that will stop it. And we want to work with you. Our mission is, one more time, to bring safe, effective, and cost-efficient medical cannabis to Michigan's patients. To do so, we shall be rewarding our friends, and we're going to punish our enemies. We're going to do that in the press. We're going to do it in the ballot boxes. We have the people, we have the skills, we have the resources, most important, we have the will. We're going to see the job through. We're going to finish it, whether it takes 3 years or another 30. I'll see you when I'm 91. Thank you for your comments.
Before we call our next speaker, I would like to apologize for the audio feedback that you're hearing. We have a lot of media here.
Greg Francisco, Dennis Hayes, Melody Carr, and Charles, I believe is Green.
Good morning. My name is Greg Francisco, and I am the Executive Director of the Michigan Medical Marijuana Association. We are the largest medical marijuana patient advocacy group in the state of Michigan in terms of both membership and geography. Our membership spans the entire state from Iron Mountain to Monroe. We have hundreds of registered members, and we're registering scores every single day. We believe that this gives us the credibility to speak for the 3,006,820 Michigan citizens who voted to protect patients who treat the symptoms of their serious disease with a whole plant marijuana. 63% of Michigan voters and every single state and Senate legislative district in this state approved Proposal 1. By almost a 2-to-1 majority, the citizens of this state have spoken. We want to protect patients. We want a sensible, workable medical marijuana program. And in the minds of Michigan voters, medical cannabis has become mainstream. There's no controversy. This is not a fringe issue anymore. It is your job as the Department of Community Health to establish a functional program that will protect patients and, by extension, caregivers, healthcare providers, families, and friends. In order to successfully establish and operating a medical marijuana program in Michigan is obviously in the best interest of our members, but it's also in the best interest of the entire state. We are not opposed to rules. We live in this state. We send our children to schools in this state. We have to rely on public safety in this state. We're not against rules. We want to live in an orderly society. We simply want rules that work. Some of the rules that you have proposed are not workable. In order to compel compliance with the rules have to invite compliance. Rules that are unenforceable, that extend the reach of government beyond the very clear limits that are established in the Act, or that are overly burdensome or technical are rules that invite violation. If the rules are too intrusive or too cumbersome, many patients simply will not register. Now that doesn't mean that they won't use medical marijuana, because they'll just keep on doing what they already do. They'll just very discreetly, privately continue to use, but they'll be outside the system. And then if they get caught, then they will rely on the affirmative defense, which will tie up the criminal justice system, which was one of the things that Proposal 1 was supposed to avoid in the first place. The rules of the Michigan Medical Marijuana Program must follow the Act itself, but there are several rules, which I will now cite by the rule, which appear to either directly conflict with the law or in which the department attempts to regulate things over which they really have no authority. Rule 21-2A gives the Department of Community Health authority to inspect grow sites. This directly conflicts with Section 6G of the Act. Rule 21-2A must be modified to remove any references whatsoever to inspections. Rule 27-1 and 23-2G require medical cannabis to be stored in a locked enclosed facility. The Act only requires plants to be cultivated in a locked enclosed facility. This rule is patently absurd, and it just defies common sense. We trust Michigan citizens to keep far more dangerous drugs such as Ritalin, OxyContin, or Xanax in their bathroom medicine cabinets. Storing medical cannabis inside a locked enclosed safe makes it more difficult for round-the-clock healthcare providers and family members to assist that patient. These two rules have to be stricken. Plant inventories and tracking logs. There is no mention in the Act of plant inventories or production logs, yet several rules refer to plant inventories and attempt to closely track each plant to a particular patient. This scheme is not only overly burdensome, but it's unworkable, and it's quite likely that it will lead to technical violations of the law, intended or inadvertent. Requiring caregivers to track every plant from seed to medicine, that's like asking a vintner to track which grape goes into which bottle of wine. It's just not going to work. The inventory requirement is so vaguely defined and the log requirements are so ambiguous that even well-intentioned caregivers that are making good faith efforts to comply could easily find themselves running afoul of the law. Inventory sheets and logs are self-incriminatory of violations of federal law, and it's just unrealistic to believe that caregivers are going to voluntarily hand them over to law enforcement or agents of the state. All requirements for inventory sheets and tracking individual plants have to be removed from the rules in order to make them consistent with the law. The proposed rules, Rule 25, the proposed rules disqualify patients and caregivers for reasons that do not disqualify them under the Act, including federal convictions for things that are legal under Michigan law. The Act does not qualify patients who are convicted of drug charges unrelated to their use of medical cannabis, and it only bars caregivers who have felony drug convictions. Yet the rules unreasonably attempt to disqualify all patients and all caregivers upon conviction of any drug offense. The second general category is that the rules have to protect privacy. Several proposed rules are serious threats to the privacy of patients. One of the most glaring breaches of privacy is contained in Rule 315. Patients designating a primary caregiver are required to list all other qualified patients being assisted by that caregiver. Now, when I go to the pharmacy, I don't have to tell my pharmacist every other patient that my doctor has written a recommendation or prescription for that particular drug for. It's not my business who else the doctor is writing prescriptions or recommendations for. And it's not something the pharmacist needs to share with me. That's just got to go. There's just no compelling reason whatsoever that one patient needs to know the identity of any other patient being assisted by a particular caregiver, particularly when it's just a matter of checking your own internal records to find out. Rule 9.1 allows the department to contact the Social Security Administration or other federal agencies to verify that a patient is eligible for a reduced fee. Using medical marijuana is still a violation of federal law. Informing the Social Security Administration or other federal agency that a patient receiving federal services is also a medical marijuana patient puts that patient in peril of losing federal benefits. The department should not be allowed to violate patient confidentiality in this manner without first obtaining written permission or offering patients the opportunity to pay the full application fee. Rule 21, confidentiality. This entire rule has to be modified. Confidentiality is not consistent with the protections provided in the Act. Rule 21.2a speaks of gross site inspections, which more often than not will require opening a patient or caregiver's homestead to agents of the state. Rule 21.2b would allow law enforcement fishing expeditions based on mere suspicions and hunches and clearly violates Section 6H3, which only allows the department to verify that a card is valid. And 21.2c allows one person to authorize release of private information about another. This entire rule needs to be brought into line. As discussed earlier, the record-keeping and inventory requirements contained in the rules are not consistent with the Act itself, but they also violate privacy. Patients rightly fear turning over written records of federal law violations to local law enforcement agencies. There's no guarantee that once those inventories are submitted that they won't be passed on to federal officers and used as the basis for federal prosecutions. Requiring inventory sheets is a violation of our Fifth Amendment rights. A patient's front porch and living room window is not a public place. Yet Rule 117 attempts to redefine these private spaces as public and prohibits patients from using their medicine on private property that is only visible to the public but not open to the public. Rule 117 is unreasonable, and it's contrary to the Act, which prohibits smoking of medical marijuana in public places only, not places that are potentially visible to the public and not use in the public. It only says smoking in public places. And lastly, the rule writing should not be used as an excuse to expand the department's authority beyond what is provided in the Act. The Michigan Medical Marijuana Act is a tightly written piece of law which gives Michigan Department of Community Health very limited powers to carry out very limited functions. The Act envisions the department taking applications and issuing or denying cards based on certain objective criteria. This is what the voters approved. The rules, on the other hand, seem to envision the department taking on an investigatory and law enforcement role, and this is contrary to both the letter and the spirit of the law. References to inspections must be removed from the rules. Inventory and plant log requirements must be removed from the rules. Rules giving Michigan Department of Community Health arbitrary authority to deny and or revoke registrations that otherwise meet the strict requirements of the Act must be removed. And rules giving Michigan Department of Community Health arbitrary authority under the Michigan Medical Marijuana Program to examine patient medical records based on factors such as number of recommendations written by the patient's physician, complaints against that physician from other physicians, or other ambiguous considerations must be removed. These matters are better addressed through existing processes for supervising and sanctioning questionable physicians, processes that do not directly involve uncomplaining patients. We, the members and associates of the Michigan Medical Marijuana Association, want the Michigan Medical Marijuana Program to be successful. We, the citizens of this state, have spoken clearly that we want to protect seriously ill patients by establishing a workable medical marijuana program. We, responsible, informed adults living in a free society, we want our government to protect us from other people that want to harm us, not try to protect us from ourselves. We, responsible, law-abiding adults, should not be treated like criminals. So speaking on behalf of the Michigan Medical Marijuana Association, and by extension, 3,006,820 Michigan voters who approved Proposal 1, we encourage the Michigan Department of Community Health to listen carefully to the testimony you received today and then give thoughtful consideration to the written comments that have been submitted. Go back, revise the rules to better protect patients, more closely follow the direction of the electorate, and give us a workable set of rules that invite compliance, that do not invite violation. Thank you.
Mr. Francisco?
Yes.
Did you have a written statement with you today?
I will mail this to you because I ended up on my, when I was marking it up even as RD was talking. So I will mail you that by the 9th.
Okay. All right, thank you for your comments.
Hello, my name is Melody Carr. I'm also a founding member of the Michigan Medical Marijuana Association, and I serve on its executive board. I have 10 years of experience in human services, working with people with disabilities, their families, and state and federal regulations. And I also have nearly 10 years advocating for and assisting medical marijuana patients specifically, people who are under abnormal stress because of their conditions, because of the rigors of their daily lives, because of their financial situations related to that, and because of the unnecessary burdens that they face dealing with the black market, dealing with fear of law enforcement, and all of these things simply for using a medication that has been shown to be effective for them and that has been approved by their doctors. And most importantly, I'm one of the 3,006,820 Michigan voters who approved this law as it was written, with the requirements and safeguards that are contained in the law itself. What the Act charged the department with was a very specific and limited task: setting fees for ID cards and procedures for processing applications, and procedures for considering additional conditions to be protected. The rules that we've seen, the proposed rules, they frankly, some of them look like they were just written for the sake of writing rules. They reflect people that have not really had a lot of experience with the patients that they're dealing with, and some of them go beyond the law. They require additional information and proofs that the law does not require. Some of them even directly contradict the law, like the required inspections. And many of them are overly burdensome. They lay the responsibility of patients on excessive self-incriminating paperwork, like the inventories. They require patients to violate other patients' confidentiality, as others have mentioned. And some of them are downright dangerous, like the requirement to disclose grow sites. The department does not have a lot of experience with medical marijuana laws and procedures in and of themselves, and security is a big concern for a lot of people. And many of them have no precedent either among other medications or among the marijuana laws in other states. No other medical marijuana state requires usable marijuana to be locked up. No other medications like Vicodin, Xanax, Oxycontin, other things that are obviously more dangerous than medical marijuana. We don't require patients to lock these up. If a patient dies and they have a prescription for Xanax, Oxycontin, other dangerous pharmaceuticals, their caregivers, doctors, families are not required to turn these over to law enforcement officers. Many of these provisions require people to incriminate themselves, require people to participate with law enforcement, and these are people who are already used to being pushed to the fringe, used to being looked at as lawbreakers. The rules reflect a mindset that marijuana is illegal. Well, marijuana is illegal federally, and other marijuana use is illegal in Michigan, but this is medical marijuana that has been approved by Michigan voters for Michigan citizens. And we need to move beyond that law enforcement paradigm into a public health paradigm, which is what we're trying to do here. We're here to help. We want to help the department, we want to help law enforcement officers, we want to help the patients. These rules not only burden the patients, but they also burden law enforcement with increased responsibilities. They burden the department with increased oversight for things that are not even contained in the law. I'd like to encourage the department to listen to all the comments here, and really, if possible, I believe that there should be at least one more hearing in a different area of the state to accommodate some of these patients that are unable to travel long distances in the winter, that are unable. I know at least one person here who did travel from Marquette. So that will tell you how important it is to these people, but a lot of people simply are not able to make long trips, and accommodation should be made for them in a public health law. And I would just like to encourage the department to listen to the comments that are made today, to review carefully the written recommendations, and I will be submitting comments with the citations of the specific laws, and to come back with a plan that will work. In order for rules to work, they need to be workable, and some of these are unnecessary, and they will simply function to drive people off the grid and not participate in the program. And that's not what any of us want. We all want a program that works, that is safe, and that provides safe, reliable, and affordable access to patients. Thank you.
Thank you.
Good morning. My name is Dennis Hayes. I'm an attorney, and I am representing the Michigan Medical Marijuana Patients, which is a different group than Mr. Francisco's group. And I would like to indicate that we thought Mr. Francisco's website was so good that we just linked to it rather than repeat all of the accurate information he had in it. As an attorney, I am deeply concerned about the proposed regulations and the I assume accidental oversight and the lack of information about a person's criminal exposure if he complies with the regulations that are drafted. I am sure you are familiar with the Fourth Amendment and the Fifth Amendment. The Fourth Amendment in particular gives you the right to be free of unreasonable searches and seizures. The proposed regulations compel, give the Department of Public Health or Department of Community Health the right to conduct inspections of grow sites, which is just unimaginably intrusive, and does not even require the minimum that a law enforcement official would require to conduct any investigation into any particular grow site, or in fact, I think it's rule, for example, Rule 317 or 317 would require that a caregiver provide a criminal history when the legislation clearly, explicitly says that the only person who cannot be a caregiver is someone with a prior drug felony. To require somebody to disclose, have an affirmative duty to disclose his entire criminal history as a condition of being considered as a caregiver, it suggests a level of knowledge that most people don't have. People like to forget that they had run-ins with the law. They forget the dates, they forget the times, they forget the places, they forget the disposition. This information is available to the department simply by a CCH search, which costs $10, and you can deduct it from the $100 fee. That information the state records will provide you with the information about whether the person has a drug conviction or a felony drug conviction. There are many, many people, including many patients, who have misdemeanor convictions for the possession of marijuana because they self-medicated. There are many other people, college students, high school students, lots of people have misdemeanor convictions. There shouldn't be any interest or purpose served by compelling people to disclose their prior criminal history. That's very, very cumbersome, and it serves no purpose. It serves no purpose authorized by the legislation. It serves no functional regulatory purpose for the department to know people's misdemeanor records or felony records unrelated to drug convictions. You also have a section in there, section Rule 9A, gives the department the authority to compel a face-to-face meeting if they have any questions about the person's information. This is, besides being burdensome and difficult for a lot of patients and or caregivers to have to come to a face-to-face meeting, it also imposes a burden on the department to go to face-to-face meetings if people are in wheelchairs, if people don't have transportation, if people are unable for whatever reason to get to a face-to-face meeting. These are unnecessary, and these regulations should be stricken completely. the overarching issues of self-incrimination or violation of your Fourth Amendment rights and the corresponding rights in the state constitution is an issue that should be addressed. I don't believe, from what I've read of the proposed regulation, that this was even seriously considered or brought to your attention that there were federal and state constitutional complexities to what you were demanding. You also have assumed responsibilities under the regulations that are way broader than the police powers. Your ability to conduct inspections, to inspect grow sites, to inspect locked, closed facilities, makes you more than police without the protections that are available to the citizens from the police. The law requires probable cause to investigate anything. These regulations don't. They suggest that the department, for purpose of verification, for purposes of its own authority under the rules, to act in a manner that would be a violation of the Fourth and Fifth Amendment rights of the patients or the caregivers. As a lawyer, I couldn't advise a patient to comply with these regulations, because to do so, to file an inventory, to turn over your marijuana to the police, to disclose the names of caregivers, all involve violations of federal laws. And we are all witnesses, and many of us are victims to the federal law and the federal government's sort of ignorant insistence that medical marijuana patients should be treated as criminals. This is inappropriate, and I would think unconstitutional as well. I don't believe that the department intended to put itself in a position of being superior to the Constitution, of its needs being more important than people's constitutional rights, or that patients should have to surrender constitutional or statutory rights in order to comply with the law. The law is, even though Mr. O'Keefe and I have had some disagreements about the way the law is drafted, the law is drafted in a very particular, narrow way, and it is designed to protect people and to protect patients against possible criminal violations. And the gathering, and I would also add that the gathering of all this information, which would be reachable under the federal law by a simple subpoena, would compel the department to disclose this information without any logical defense. So the gathering of this information places the department in the position of being an unwitting and even unintentional witness against the very patients that the law is designed to protect. I cannot overemphasize the importance that you not place yourself in a position of being an unwitting accomplice to the prosecution of your patients. This is just directly, extraordinarily makes you complicit with the federal government in the attempts to punish people who are trying to serve their medical needs. I have submitted a statement which contains all these objections in more specific ways. I think the other point that I would make with regard to the constitutional rights is that all of the information you're asking these people to provide would be, in essence, a written confession. That confession is reachable. And you clearly, and I don't believe legally, have much defense against the federal grand jury subpoena to turn over your records of all the people who submit their information about their inventories to.
Mr. Hayes, I'm sorry, I don't mean to cut you off, but if you could go ahead and try to wrap it up so that we can make sure that everyone has
Sure.
a chance to speak.
Mm-hmm. Those are the main points. I think the other point that I think is important is that in the proposed rules regarding the addition of additional debilitating conditions, the way the rules are set up, there's no guarantee or there's no outline for the establishment of the review panel as it's described. The review panel should be composed of people who are objective or at least neutral about the issue of medical marijuana. It surely should be, medical professionals should be in a continuing majority on that committee. The rest of the panel, regardless of its composition, and I would submit that you should have defense lawyers, you should have patients, you should have people who are more knowledgeable, obviously, than the people in law enforcement. Talking to the law enforcement people or the regulatory people about medical marijuana is like asking the Pope for birth control advice. I know you have a hard job, and that you weren't given much time. And I think the suggestion that you have additional opportunity for people to speak after you've had a chance to review and absorb what I am sure will be an overwhelming amount of what are you doing.
Yeah. Please, just got to cut you off now. I want to make sure that everybody has a chance to speak. But thank you for your comments. Thank you for submitting them in writing. Everything will be reviewed, and the department will take all of your comments into consideration. But I just want to go ahead and move along so that everyone has an opportunity to speak.
Well, I can only speak for another half an hour.
Hi, my name is Charles Ream from Ann Arbor. I worked on the Ann Arbor Medical Marijuana Initiative, which passed at 3-1 instead of just 2-1 in the state vote. I carry my doctor's card in my doctor's letter in my pocket all the time. 1968, I got extraordinary stomach pain. I'm sure other people in the world have had greater pain. By the end of 1968, I was ready to take myself off of this planet. And I discovered cannabis, which enabled me to have a good life, 33 years of teaching kindergarten, 5 times elected as a trustee in my township. I now am a counselor using neurofeedback to try to help children and other people. I cannot understand why the rules were written in such a restrictive manner when the language on the ballot was so very, very clear. Could it possibly have been written because people think there's some great danger? Well, there isn't a great danger related to cannabis. The DEA's own judge said that this was the most therapeutically active, the safest therapeutically active substance known to man. You can die from drinking too much water, about 5 gallons. 100 people die every year from peanut butter, and no one has ever died from cannabis. The real reason I came here today was because I would like to be a caregiver. I would like to grow cannabis for 5 people. People who can't grow it for themselves. People whose hands are crippled up with arthritis and they can't actually function to grow marijuana. I would like to help them and take it to them and it would make my life better to help people that fundamentally.
Mr. Ream, do you have a comment about a specific rule?
Yes, sir. And I do want to say that the reporting requirements that would relate to me telling my inventory for each patient would make it impossible for me to function as a caregiver. I simply wouldn't do it. I would be too afraid about making a mistake with all of these reporting requirements, and I wouldn't be a caregiver. And all these people who would need the care would not get the care because I would be in too much fear. There's the possibility that you might tell police where a person's grow room was. I don't think anyone's going to participate in the program under that situation. I'll have my notes written up in a better form, and I'll have them to you by Friday. I think that it is critical that these rules don't go beyond what was on the statute. We don't just have the people of Michigan didn't just pass this, they passed this at a 63% rate with an incredible margin. It is a true mandate. And your job is to extend that compassionate use of cannabis to anyone whose doctor agrees that this is good. And these rules will still have patients living in fear. And most of the people who need medical marijuana will not get it. The citizens overwhelmingly want the words on the ballot implemented without extra restrictions. This is truly a mandate to help people I know that your job is very serious, and you will take it seriously, and you will resolve these rules so that the maximum number of people in Michigan who are suffering and need help will be able to get help. Thank you so much.
Thank you. The next speaker I'd like to call is Karen O'Keefe. Before you get started, Mrs. O'Keefe, I'd like to make one comment to everybody. There are several of the speakers who have come up have already provided some detailed testimony regarding some of the problems that they perceive with the rules. I would ask, just in the interest of giving everybody an opportunity to be able to speak, that we not continue to focus on those same rules exclusively if there are other rules that need to be addressed or that you'd like to make a comment on. The written testimony that everyone is required to provide, we will go ahead and review that when the department conducts its review. But I would just ask that if someone has already spoken about a rule, and I would just ask that we not go ahead and continue to go over the same rule repeatedly, just so that everyone has an opportunity to speak. Okay, Mrs. O'Keefe, thank you.
I'm Karen O'Keefe. I'm an attorney and the Director of State Policies at the Marijuana Policy Project. I was the lead drafter of Proposal 1 in consultation with the Michigan law firm Dykema Gossett and many others. And I lived in Michigan until I was 21, and I'm proud that voters made my home state the 13th to protect the seriously ill from arrest. The safeguards included in Proposal 1 were carefully considered based on what's working in other states and what is possible without being overly burdensome to people facing serious illnesses. The law is careful not to create problems given that federal law does not yet allow medical marijuana. It's most closely based on Rhode Island's law, which is working so well that more than 85% of legislators voted to make it permanent after a one-year trial period. As is the case in Rhode Island, Proposal 1 is very specific about the department's role, which is very limited. The department's job is to process ID cards, to confirm their validity to the police, and to consider petitions to add additional conditions to the ID card program. The only rules that Proposal 1 authorizes the department to create are rules for setting fees for ID cards, procedures for processing applications, and procedures for considering petitions to add additional debilitating conditions. In Rhode Island, that's exactly what the department rules did. Michigan's draft rules instead seek to add onerous and unreasonable restrictions on patients. In several cases, they contradict the language of the voter-enacted law. The rules need a comprehensive revision to conform to the compassionate law that voters overwhelmingly enacted. I've submitted written testimony with 22 revisions that are needed, and will highlight a number of them now. Yes? Slower? 63% of Michigan voters decided that they did not want the seriously ill to be treated as criminals. Yet the draft rules envision a monitoring and inspections role that would treat the seriously ill like criminal suspects for being allowed to use their medicine. Just as the department and law enforcement are not allowed to invade the privacy of patients' homes based on them having a Vicodin prescription, Proposal 1 specified that a patient could not be subject to search or inspection solely for being a state legal medical marijuana patient. Proposal 1 does not permit the department to monitor patients, and it explicitly forbids inspections. The draft rules must be amended to remove this unauthorized and invasive role, which is in Rule 23 and also 21A. Similarly, none of the 12 other medical marijuana states require patients or caregivers to produce inventory reports. Neither does Proposal 1, yet the draft rules require that these reports be produced and say that a renewal card will not be issued if the reports are not provided. The law clearly lists the only reasons that an application can be denied, and not submitting inventory reports is not one of them because the law does not require inventory reports. Proposal 1 already protects against diversion by increasing penalties if anybody diverts marijuana for non-medical use. The inventory reports are unnecessary and overly burdensome, and they must be stricken from the rules. And they also would be self-incriminating because of federal law, as others have mentioned. Another part of the draft rules that needs revision is the possibility of requiring a face-to-face meeting to verify a patient's identity. As others have said, it can take up to 9 hours to drive from the furthest part of Michigan to Lansing. Several patients who wanted to be here today to urge the department to revise the rules could not make it because of their health problems. Some people with debilitating illnesses cannot travel for long trips, and it would certainly delay them getting their card if they had to travel to Lansing first for a face-to-face meeting before they could get that card. In addition, the draft rule does not create a clear standard for when the department might require this burdensome trip. So the possibility of requiring a face-to-face meeting, which is in Rule 9A, must be deleted. The language about doctors and written certifications also needs to be revised. Proposal 1 says that the department shall issue an identification card to a patient who submits his or her application with a written certification and fee, and that a patient's application can only be denied if information is falsified or is missing. A certifying physician must be a DO or MD who is licensed to prescribe drugs. Yet the draft rules allow the department to take things into consideration when granting or denying an application that the law does not, such as complaints by healthcare providers about that physician. If a physician is unfit to practice medicine, the proper venue where that will be addressed would be physician licensing, not when issuing a written certification. The draft rules would also allow the department to require some patients to submit their private medical records. These rules need to be revised to conform with the statute. Let's see. The draft rules language on verifying cardholders' status to law enforcement is also at odds with the voter-approved law. Confidentiality is key to the act and essential to the success of the ID card program. The new law punishes a breach of confidentiality by up to 6 months in jail. The law provides that the department can verify to law enforcement that a specific ID card is valid. In contrast, the draft rules say the department could confirm whether a person is a registered card holder if law enforcement has a bona fide reason for the inquiry. This would allow for fishing expeditions, which would violate the Act's confidentiality requirements. This needs to be changed to conform with the law so that an ID card would only be verified rather than allowing fishing expeditions. In addition, draft rules conflict with Proposal 1 by disqualifying patients and caregivers for convictions that do not disqualify them under the law. Proposal 1 does not disqualify patients for any unrelated drug conviction, and caregivers are only disqualified for drug felonies. A serious violation of the medical marijuana law, such as selling marijuana to a non-patient, would also result in a revocation, but the department does not have the authority to rewrite the law to exclude bona fide seriously ill patients for unrelated drug convictions. Voters enacted Proposal 1 as it was written. They were satisfied with its safeguards, which were carefully considered and are working well in other states. The department's role now is to implement the law, not to rewrite it. The rules need to be modified in several areas to avoid overburdening patients and to comply with the spirit and the letter of the law. In addition to the problematic rules I've discussed, several other changes are needed, which others have discussed and which I've submitted in writing. The law is extremely specific and gives the department a very narrow role. The department does not have the authority to rewrite or to violate the law. If the rules are not rewritten to conform with the law that voters enacted, it is inevitable that they will be successfully challenged in court. In the meantime, patients would suffer. It's to everyone's advantage that the rules be swiftly revised and that the law be faithfully implemented. Medical marijuana laws are working smoothly in states like Rhode Island, and they will here as well once the revisions to the draft rules have been made. Thank you for your time.
Thank you.